Footman?
Yes.
Appeal of the state of Florida and for the second district is now in session. The Honorable Robert J. Morris, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. You may be seated.
Good morning, everyone. Welcome to the Second District Court of Appeal. We have a number of cases on the docket this morning. You've probably seen the docket on your way in. We'll call the cases in the order in which they appear. The ground rules are pretty well known to everyone, but let's go through them again just to be sure we all know. Each side has 20 minutes, up to 20 minutes to argue. Doesn't mean you have to take all the 20 minutes. It means that's the maximum amount of time you have. The appellant can reserve up to 5 minutes of their 20 minutes to rebut the argument that the appellee makes. And I keep time right here. This is not, I'm not particularly good at this. I've been known to pay attention to your arguments and the time keeps running. So I'll let you know when you get to where you need to be and tell you what your options are. So our first case is Robert Lee Bean versus Julius Footman. We're ready whenever you are. The appellant can approach the podium.
Good morning, judges. My name is Robert Lee Bean. The issue at hand it involves a residential lease agreement, and the appeal is about the motion to determine rent and subsequent order of possession. My issues here today are jurisdiction and errors created by the lower court and jurisdiction. The appellee was barred from filing the eviction action altogether for possession under collateral estoppel. The landlord, Mr. Footman, the appellee, was an agent for our grandmother, May Flowers, the principal, who is now deceased. When this action was filed in March of 2022, March of 2022, there was already a pending unlawful detainer action filed by the principal and successor agent that was filed in December of 2021. So by that still pending, that case didn't conclude until September of 2022. But the appellee went ahead and filed for an eviction, although the unlawful detainer case was still pending, and the parties were still actively litigating the outcome of that case. Also, the amount of controversy exceeded the lower court's jurisdictional limits because in the eviction complaint, the appellee included 4 of the 7 pages of the lease, whereas 5 through 7 included a lease option that had already been exercised and consideration had been paid. So it was a contract pending completion. With that being said, the amount of the sale and the amount of controversy due to the terms of both the lease itself, the conditional terms of the lease itself, and then also the option exceeded the lower court's $30,000 jurisdictional limit. The next thing is the lower court relinquished jurisdiction when ordering parties to mediation. There was a motion to dismiss hearing, and then 10 days later, there was a motion to determine rent hearing. Between that time, the court ordered the parties to mediation, but I didn't receive a copy at all. I didn't even see it in the docket prior to us attending the motion to determine rent. By me not receiving that and the court not bringing it to our attention while we were at that hearing, it deprived me of due process. And also because once mediation started, it's my understanding the court has stayed from further proceedings until mediation has concluded, and mediation hadn't concluded at that point in time, and it was court ordered, I guess on the court's own motion. The errors that I have, the eviction complaint was filed in March of 2021, but we did not make it to court until October of 2021. So I had timely filed a motion to determine rent with my answer on or about March 15th, and I followed up with the court repeatedly, and the court basically just said, just wait for the judge. There wasn't a delay in the docket. We didn't go into court until September when I filed a motion to dismiss, and I think at the same time, a day or so later, the appellee filed a motion for default. And that's what brought us into court initially. The court had not moved on the motion to determine rent, and it didn't seem that they were going to make a move until we filed those 2 motions. So those delays created forgive me for a second. Those delays thwarted the legislative intent of me having to pay rent in order to continue defending the action, because there was a 7.5-month delay of the court taking no action to hear the motion to determine rent. The next error was the failure to review case files to ensure standing in jurisdiction and also to properly determine the amount of rent owed. In the lease itself, the appellee was supposed to receive a certain amount of money, and there was a certain amount of money that was supposed to be paid directly to the principal for specific reasons. The court didn't review those files. They didn't listen to my objections. But that in itself, by not adhering to the lease itself, the contract that brought us into court, the court erred, and that led to their erroneous amount of rent due in their order. So basically, when they inaccurately determined the rent, they didn't provide any kind of information on how they came about that amount, nor did he state it in court. It is inconsistent with the appellee's ledger. It's inconsistent with my testimony. It's inconsistent with the lease. So I don't know where the amount was derived from, but it was erroneous altogether. I'll reserve 5 minutes for any rebuttals, but that's all I have.
Okay, thank you, sir. So you'll have the 5 minutes when you come back. Yes, sir.
Morning, Judge. My name is Julius Flipper. I'm the appellee, however you say it, I forget. But as far as this case about the lease, I have the paperwork, everything matched up, as far as what he owed for the rent. He had numerous amount of months to even say, hey, here you go, Julius. Nothing was given in the rent. He made a bunch of frivolous accusations to lead me and him to even get to this point. I have the whole agreement. Everything was furnished correctly in the courts, all the necessary paperwork. What me and the judge went over, or what the judge went over with me and him, and he read it thoroughly and carefully. It's all documented, and I have it all. And I feel that the lower courts did a perfect and adequate job by going through and seeing he had ample amount of time. Like I stated, the time was given. And for one of the things he said in the court, he felt that he didn't have to pay rent at all. And that's kind of, not understanding on what he said was in the lease. And that's pretty much it.
Thank you, sir. Sir, you have up to 5 minutes.
I don't really have much to add to that. There was nothing new that he stated that was outside of his brief. I did forget to include one of the errors that the court made. If I am able to do so.
Sorry, what do you want to do?
There was one other issue and matter I wanted to raise and argue here that I didn't get a chance to.
Okay.
Am I able to do
I mean,
that?
ordinarily, your argument is to address what he said, but I'm going to go ahead and allow it. I'm not sure what you have to say.
Well, like I stated earlier, our grandmother, the principal in the power of attorney, had already passed. She had a will that was deposited with the court. The will listed beneficiaries, and under both the rent that was supposed to be paid directly to her and the amount of the sale of the house that was supposed to be divided between the beneficiaries, when the court allowed him to come in and represent the matter or argue the matter without notifying those beneficiaries because she had passed, they allowed Mr. Footman to allow him to basically partake in the unlicensed practice of law, because he then represented the interests of the beneficiaries listed in the will at that time during each hearing, because she had already passed. That's all.
Thank you, sir. Thank you both. Well, we're done. We've got to stay by the rules, okay? And we're all through, and I appreciate what y'all did, okay?
Thank you.
Thank you. Our next case will be Sarasota Doctors Hospital and Englewood Community Hospital versus Sarasota County.
Sure.
Water report.
Sure.
Okay, so we have basically on the docket today, as you all know, two cases that are pretty much the same. We have this one and we have the one that follows it, Venice HMA versus Sarasota County. Very similar cases, except for the second case has got two issues that aren't in the first case. So we discussed among ourselves how we're going to handle this, and we're just going to treat these as two totally separate cases, give everybody their full 20 minutes, and we'll, because this is a big case, important case, complicated case, and hearing some things twice isn't going to be a bad thing, okay? So I just want you all to know that. So would you like to reserve 5 minutes?
I would, thank you, Your Honor.
We're ready whenever you are.
Thank you. May it please the court, I'm Steve Essenia, and along with my partner Gabe Warren, we represent Sarasota Doctors Hospital and Englewood Community Hospital. We're here because the trial court adopted Sarasota County's position that its sovereignty allows it to ignore a constitutionally valid payment obligation in the Special Act. The trial court disregarded that the Florida Supreme Court upheld as constitutionally valid the very reimbursement provisions in the Special Act that are...
Anywhere in that opinion did they mention sovereign immunity? And I know you all briefed this issue, so I'm giving you a softball
Sure.
question.
No, Your Honor, but the finding that the county's charter powers didn't excuse the payment obligation is a very parallel argument to the argument that we're making here. The Supreme Court found that payment obligation was mandatory, and that's what we have here, a mandatory obligation on the county where sovereign immunity is completely inapplicable. And so if that payment obligation is to mean anything, which
so
is...
your arguments is it's a ministerial act? You're raising
The payment is a ministerial, the payment itself, the function of paying is a ministerial act because the Supreme Court upheld the constitutionality of the Special Act.
There's no question they did that. But the real question is, did they address sovereign immunity or did they need to? Is there is this law the case and this is issue preclusion?
Absolutely. I think that it is because not only here, but in Sandegren. In Sandegren, the court found that a valid payment, again, Sarasota County tried to avoid their obligations under the Baker Act to pay for health care. A very similar health care initiative. It was a general law.
Based on a general act.
It was, but that's a distinction without meaning.
I'm getting confused here. So you're making a law of the case argument, but now you're bringing in Sandegren. I mean,
Well, it
there's two
supports
separate
it.
arguments, right? One is that the prior appeal in this case is law of the case, and as to sovereign immunity, as a sovereign immunity, and then you're also making a parallel argument about a case that, by analogy, makes your point that sovereign immunity doesn't apply, right? Let's keep these things straight.
Yes, sir, but I would say that the Supreme Court, in upholding the statute, Sandegren is supporting what the Supreme Court's already done in this case. The Supreme Court in our case had before it the issue of whether Sarasota County had a mandatory payment obligation on it. The court found that it did. Here, the county and the trial court don't even want to get to the issue of whether sovereign immunity is applicable. And it's a distraction. They're suggesting, waiver's the question. But you don't even get to waiver without determining whether sovereign immunity is applicable. And here, clearly, sovereign immunity is not applicable. I couldn't find a case, there is no case that the county has cited where sovereign immunity has been held applicable where you've got a valid special law. And that's the situation we have here. I mean, the court's opinion will have no meaning, and the legislature's action would have no meaning if this court finds the county's position persuasive.
Let me ask you this, okay, so there's no meaning, but if, to play the devil's advocate here, I mean, there's no private right of action because of sovereign immunity, but that doesn't mean that doesn't necessarily, the conclusion has no meaning.
Well,
I mean, if a tree falls in the woods and no one's there to hear it physically fall, I don't know, but I mean, there's no one to sue to enforce the obligation of the special act, does it have force and effect? I don't know. It is the fact that sovereign immunity might foreclose private action to enforce the duties of Sarasota County under the special act. Does it mean that it renders the act of no force effect? I mean, because of other ways in which it could be enforced?
I don't know how else it could be enforced, Your Honor. I mean, we have a situation here where the court spoke. You know, the county raised the issue under its charter powers. They're not compelled to pay for the indigent care. They were, as a county, sovereign. But we have to remember that sovereignty flows from the Constitution. And what the legislature is the superior body here. The legislature has the power to dissolve counties if it chooses to do so. The legislature spoken in a constitutionally valid mandate here, saying that the very issue at the heart of the case was the payment provision in the special act. The county had no problem with any other part of the special act.
So section 125.01 of the Florida statutes, powers and duties of counties. Section 1 reads, the legislative and governing body of a county shall have the power to carry on county government to the extent not inconsistent with general or special law.
Yes, sir.
Does that impact this case in some way?
Well, certainly, you know, it is inconsistent with the county's actions here are inconsistent with the special law that the legislature imposed on it.
You've read these briefs just like I have. You know, there's a huge argument whether sovereign immunity applies to a general act or a special act.
No, that's not really the issue. And the county has conflated the issue of the applicability of sovereign immunity, which is a different question of waiver. We don't assert that you know, special act can waive sovereign immunity. But if you look at, you know, some of the cases that we cited, particularly Bill Stroop, Roofing and Palm Beach County versus Town of Palm Beach. In both of those situations, the courts found sovereign immunity not applicable because the county was trying to impose an obligation that was inconsistent or avoid an obligation that was inconsistent.
But those were general act cases, weren't
they? They were general act cases, but I would say to you, Your Honor, the county has not cited a single case to us to say that the county is excused from abiding by the requirements of a special act. Otherwise, with the special act would, you know, the county, anytime it chose to do so, could say, you know, we don't really like the obligation that the special act is imposing on us, so we're going to assert sovereign immunity for the legislature's will.
I mean, doesn't this statute address that in a very cryptic way?
I'm not sure.
The statute that I just read to you, doesn't that address that issue in a very cryptic way, that they have the power to carry on county government to the extent not inconsistent with general or special law?
Well, I would say that it's absolutely inconsistent with the special.
Do you think if the legislature felt there was a dichotomy, they would have said inconsistent with general law only?
I mean, I think that, maybe I'm misunderstanding your point, but I believe that this...
You won't be the first one.
No, the county's actions here are clearly inconsistent with the requirements of the special act, so it doesn't give the county the authority to avoid that. I mean, I'm sorry, go ahead, Your Honor.
Let me ask you this is what the distinction you're drawing. So under the Constitution, the legislature can waive sovereign immunity by general law. But you're saying that that's a distinction between the issue of whether sovereign immunity applies in the first place. And so, in other words, the general law concept only applies in the context of waiver. Am I correct?
That is my position.
So your concept is it doesn't matter if these cases, Stroop, that's, I'm saying that correctly.
Stroop, yeah.
Yeah, it makes no difference that the mandate, the legislative mandate that brought that case outside the ambit of sovereign immunity was derived from general, special law.
Correct.
Because the special versus general law distinction only applies in the context of a waiver of sovereign immunity that's already been established.
It's exactly our
So
position.
could you talk more about, but do you have any cases in which this concept, this clear legislative mandate concept, for lack of a better phraseology, has been applied in a scenario in which the duty to which sovereign immunity doesn't apply derived from special law?
Not from a special law, but the county can't
You
point.
think that's just incidental, that's just happenstance? You know?
Well, I mean, we do have the case. I mean, I think that although the court didn't use the word sovereign immunity, by determining that the county's obligations as a charter county, the county argued before the Supreme Court that it should not have to pay, that the mandatory payment obligation in the special act shouldn't apply to them because they're a charter county. They argued that their budget authority under
But it's a very different argument than sovereign immunity. Sovereign immunity is you can't sue the sovereign.
Right, but the sovereign is the state, and so essentially here the state has told the county, the county is the sovereign. The state is the sovereign. The county's sovereign immunity only flows from what the state affords it, and here the state has spoken. The state has said we have a valid. We're enacting a requirement that you pay for indigent care. The county, for years and years and years, accepted that obligation. They recognized as late as the 2000s, in the late 90s and the 2000s, 2 different county attorneys and a county administrator recognized the obligations of the special act, finding that it could only be repealed. The only way to avoid it was to repeal it. They were looking at how to avoid it in the context of another ordinance, a county ordinance in 1972. And so, I mean, the county knew that this obligation was on it. It was only after the Supreme Court ruled, years into this litigation, that they belatedly raised the argument that sovereign immunity exempted them from the payment obligation.
Yeah, there's a Stroop to me, reading briefs, seems to be the best case to illustrate your argument that sovereign immunity doesn't apply in the first instance. You can correct me if I'm wrong, if you like, but
No,
better. So, but in Stroop, in the cases that cited, I think a federal case, I think parties discussed it, they characterized the holding of Stroop in a manner that could be analogized to this case, or could probably be distinguished, but that is that you can read this through narrowly, or you can read it broadly. Narrowly read is that sovereign immunity can't be asserted against a claim brought by an entity or an individual who is seeking disgorgement, essentially, of funds, fees imposed in violation of a mandate against such fees, a prohibition on such fees. Is that here? But here, it's a little bit different. Here, the plaintiff in this case is seeking payment in the first instance, meaning they're seeking the payment, not disgorging funds that they were required to be paid by virtue of a fee or tax imposed in interrogation law, but they're saying, you have a duty to give me money. Is that a distinction without a difference?
Yeah, I think it is. It's just the opposite side of the same coin. I mean, the principle is still the same. There was in Stroop, there was a mandatory obligation, or there was a law that precluded the fee that was charged. Here, there's a law that requires the county to do something. I mean, I think it's astounding that the county can be here suggesting that the special law has no meaning. I don't know what meaning the special law would have. The very provision we challenged is the reimbursement provision in the special act. That's what this case is about. The county's saying, well, that even though the Supreme Court upheld it, sovereign immunity gives us the opportunity to avoid it.
I mean, doesn't sovereign immunity really go to protecting the sovereign from liability? And in this case, liability was imposed by the legislature on the county. And the hospitals, as basically third-party beneficiaries of this, merely performed the work and submitted an invoice. Isn't that really what this is about?
Well, I think that what it's about is a valid statutory mandate on the county. I mean, the Supreme Court's opinion would be meaningless if the county... They did. They acknowledged that there is an obligation. They're just saying now that the obligation is excused because of sovereign immunity. And I just don't see how this possibly could be a case where sovereign immunity is applicable. As late as this year, in Freed versus State, the Supreme Court affirmed the state's supremacy over counties and explained that counties are creatures of the state without any independent sovereignty, and counties can't frustrate the ability of the legislature to set policy. I mean, the legislature even has the policy to abolish a county. So here, the legislature's imposed a payment obligation for the county to take care of its indigent residents. And that benefits not only the county, it benefits the indigent residents. The indigent residents will have a payment obligation for the care that they receive at the hospitals if this act is not upheld. And requiring the county, I mean, I find it, incredible that the county's been able to evade this obligation for so many years after the Supreme Court's rule. And I think that they've raised this issue of waiver, which really only comes into place, as we've talked about, if sovereign immunity isn't applicable. But we do believe that we have established, if the court wants to go there, the issues that the fact that an express unilateral contract was formed, through offer, acceptance, and consideration, and that we, in our briefs, we briefed this extensively. I'm happy to go. I don't know how much time I have left.
You're right on it.
Okay, so we do believe that, we have established, and I also want to point out that the evidence in the case was undisputed. There is no disputed issues here. You could take the trial court's order. It's the trial court's conclusions that were reached here that we're asking this court to overturn and recognize the validity of what the legislature's done. Thank you.
You're right.
Okay, thank you.
You have 5.
Thank you.
Good morning. May it please the court, I'm Tom Elliott here with my partner, Amy Ferrier, and our co-counsel.
You've seen in your briefing, you've tried to confine us to the issue about whether or not there was a waiver by virtue of an express contract. The effort is that our opinion, which denied the writ of prohibition, Sarasota County Public Hospital District versus Venice, you seem to sort of interpret that to say, this is the issue we sent back to the trial court. I don't read it that way, so I just want to make sure, I don't read it that way, so I want to make sure I told you that up front.
Okay, well,
If you want to try to persuade me otherwise,
well,
I'll give you a chance.
I mean, it is heavily, once we get past the procedural, jurisdictional prohibition issues, it talks about whether there's a complete meeting of the minds, whether there's a contract that waives sovereign immunity. They say, the opinion says, this is a local law, which the Supreme Court agrees with. It's a special act, it's not a general law. So, and there are only 2 ways to waive sovereign immunity. One is by a general law, which this is not. And every case they rely on,
Again, the effort here is to direct us from the main issue. And the main issue, does sovereign immunity apply, period? Does it apply in this case? And whether or not it's been waived is a secondary issue.
Oh.
And it seems that your effort has been to focus us on the secondary issue, saying this is the only issue. I want to make sure you understand that I personally don't see it that way.
Okay, well, let's take a step back then. Sovereign immunity waiver basics, okay, because there is sovereign immunity for the county. I think we can all agree with that, okay? It is in the Constitution. It's not something that is granted by the legislature. That's not correct. It's in the Constitution. The Supreme Court opinion never mentions the word sovereign immunity.
But who imposed liability on the county? The legislature.
The legislature, through a special act.
Right. Nevertheless, they impose the obligation. So sovereign immunity protects against liability.
Yes.
So the liability has been imposed by the legislature.
Yes.
You've argued that sovereign immunity protects the county from paying the hospitals.
Yes.
All the hospitals did is submit a bill pursuant to liability established by the legislature.
Your Honor.
So it's the legislature that you seem to have to argue that your county is protected from by sovereign immunity, and that makes no sense to me.
Well, Your Honor, that's exactly what happened in the Arnold v. Schubert case and the Hillsborough County v. Taylor case. Exactly what happened there. They say there are no cases with special acts. Those are exactly cases with special acts. In those cases, the act said if you buy this insurance, one of them actually was they were basically variations. If you get more insurance than the sovereign immunity 68.28 tort cap, if you buy more insurance, you are subjected to the claims above the cap. That's essentially what those cases held. By special act, by special act. And the Supreme Court and then this court said, no, you can't do that. You cannot do it by special act. If they had done it.
So your argument is that the county is protected from liability imposed on them by the legislature
Absolutely.
by sovereign immunity. So
In a special act, John, in a special act.
Well,
Not by general
what the
law.
act is, I mean, it's an interesting argument that you're saying an inferior sovereign is protected from a superior sovereign imposing liability on them by sovereign immunity. And the very existence of counties, they draw their sovereignty from the legislature.
They draw their sovereign immunity from the Constitution. There's a Constitution.
I didn't use that word. You're now imposing a word that I didn't use. I said their sovereignty. The fact that they are a governmental entity, a sovereignty, they draw from the legislature. They serve at the will of the legislature. The legislature grants and denies their ability to exist.
I suppose you can look at it that way, but that doesn't mean the legislature can impose an obligation on them by special act, as opposed to special law, as opposed to a general law that applies to all the counties.
So the legislature is, so you think this is a nullity, that they shouldn't, legislature shouldn't even impose this obligation on them?
Not. In fact, actually, Your Honor, that's a good segue into, we were talking about chapter 129, and we probably didn't make as much an issue of this in the brief as we should have, but 129.07, Your Honor, taking you to a little bit later, says that if there's a contract that's not budgeted for, it is null and void.
Well, that argument you asserted in relation to whether there is a contract.
There's a contract, right, which
Which again is one step downstream from what Judge Morse is asking, but I wouldn't mind addressing it, because that, to the degree we're talking about waiver and the appellant's argument that is waived by express written contract, that argument might be asserted successfully in response to a breach of contract action, but because that argument, if I recall correctly, that statute talks about the indebtedness in null and void, not the contract for the indebtedness. So it doesn't undermine the existence of a contract for the purpose of determining whether there was an express written contract that waived sovereign immunity. So you could actually argue all day long successfully that, hey, we don't have to pay because this wasn't budgeted and the indebtedness is null and void and it's unenforceable. But that doesn't eliminate the fact that there was a contract for the indebtedness.
if we don't have to pay it because it's null and void, we get to the same place.
No, I don't think you get to the same place because, no, you certainly don't, because the defense of sovereign, the argument against the defense of sovereign immunity with regard to waiver has to do with whether it was waived by express written contract. So a county that's a sovereign can enter into all kinds of contracts and say, yeah, sure, we waive sovereign immunity by entering into this contract. And then there could be separate questions about the enforceability. You could have all kinds of defenses to the enforcement of that contract. It doesn't mean the contract didn't exist in the first place.
And they, in fact, denied there was a contract for many years.
Well, that now
Until they realized they have to get rid of sovereign. Okay, well, the law, again, the law is very clear that sovereign immunity, and I'm not sure I appreciate fully the concern, but the law is very clear that sovereign immunity can only be waived in two ways. The county has it, there's no question about that.
you're not sure you're fully understand my concern. We can go to the text of the statute. The statute says that that if you essentially contract over your budget, the indebtedness, is unenforceable. It doesn't say that there's no contract.
Well, it says you may not expend or enter into a contract, is how it starts, or enter into a contract, requiring expenditures in a fiscal year for more than the amount of appropriations each in the budget. And then later on, it says any indebtedness contracted for any purpose for either of these funds in exchange or in excess is null and void. So I think it does start with the contract, because it talks about
agree, disagree there. All right, go on.
well, the concept that, the The concept that the county may be a subdivision of the state doesn't mean that the state gets to run roughshod over the county. That's what sovereign immunity is for. And it is recognized in the Constitution. And the Florida Supreme Court says there's only two ways you can waive it. In fact, for many years, there was only one way, and that was express waiver in a general law that was clear and unequivocal. And then with the Pan Am case that came in 1984, they said, okay, well, if you've entered into a contract, you can waive it that way too, which is how we got there, because there is no question this is a special law. We've cited half a dozen Florida Supreme Court cases that say you do not waive sovereign immunity by passing a special law that mandates that you do this or that, whether it mandates you pay a judgment, whether it mandates you pay a fee, whether it mandates you pay somebody that submits a bill. That is not waived by the state saying, we've got a special law here, you got to do this. The county doesn't have to do it. That's what sovereign immunity is. They don't have to do it.
May I ask you a question I should have asked you up front? Mr. Wallace is here representing the district. You speaking for him too?
I'm happy.
Well, I'll just say that we're aligned with the county.
Right,
I was,
but I didn't, if you wanted time.
oh, yes, my comment on that, and because I didn't have a chance to whisper it to Tom, is if you need all the time, you take it. I know you've asked a lot of questions. I have just a couple of limited points that can either happen in this argument or the next one. It doesn't matter.
Okay, that's fine. Okay, so you use all the time up to your 20. If you got something left, we'll let Mr. Wallace
enough.
have it. And if you don't, then we're going to hear from you in the second case.
Fair enough.
All right.
Thank you.
Thank you. And I was going, I had it in my mind to say when I finished the introductions, but then you kind of got me with the question right at the beginning, so it's all good. So anyway, yes, sovereign immunity, the county absolutely does not have to pay the extra amount that the bill in Arnold said, the extra amount that the Hillsborough County v. Taylor thing said. It doesn't have to pay this. That's what sovereign immunity is. It has that right. Okay, and the fact that if it was a general law and applied to everybody, and that's every case they cite, general law, they cite.
Arnold and Hillsborough County cases, were those about waiver, or were those about, about whether sovereign immunity applied in the first instance?
So Hillsborough County v. Taylor it said you can't, the trial court read the statute to require a payment, okay? And this court said, no, you cannot do that because there's sovereign immunity. And when it got to the Florida Supreme Court said, okay, we don't read the statute to require that payment anyway. Okay, but this court held, no, you can't require the payment under the special act because the county has sovereign immunity. It is a direct, on-point sovereign immunity case.
We got reversed, right?
I'm sorry?
We got reversed, right?
No. You got the
Which case are you talking about? Where we held this?
Hillsborough County v. Taylor.
Okay, I'm sorry.
I'm not the earlier case in this had nothing to do with sovereign immunity. It had to do with home rule and, more to the point, the privileges. And sovereign immunity has been pled at the beginning. There was some comment about it when it was raised. It's on page 133 of this massive record, and page 268. Sovereign immunity is one of the defenses the county has pled from the very beginning. Now, they proceeded on the privilege thing because that's a pure question of law. As we thought from the opinion from 2021, sovereign immunity has factual questions or can have factual questions. That's what Judge Lucas's opinion said. Look, you got to go back and decide this
Which
factual.
opinion you're saying says that? Is this?
2021 from this court.
You're talking about Hillsborough County.
No, I'm sorry.
Was it with the 1988 case in which?
We got a lot of cases.
When you was reversed, but different. Hillsborough
The-
County, we being the second district was reversed, but on different.
I don't think it was reversed. I think, well, the only thing that what the Supreme Court did that's pertinent to this case, to this court's decision, is they said, okay, we hold that the way this trust fund was set up in the state legislation did not purport to waive sovereign immunity. Okay, and this court said you couldn't waive the sovereign immunity. The Supreme Court says we don't read it as waiving sovereign immunity. So you get to the same
What's the
result.
cause of action in Hillsborough County?
It was-
Toward action brought against the.
Yes, because it was a damages because of negligence, yes.
So yeah, so that seems pretty straightforward, that there's sovereign immunity against the damages claim.
There is sovereign immunity against everything except a general law and a contract.
Except at least according to Stroop, and the cause of action brought to disgorge a government who has imposed a fee or tax in derogation of state law.
State general law.
Well, again, you need to, I mean, we're all going around and we're all left out, but that the appellants are saying that analysis occurs before you get to waiver. In other words, it doesn't apply at all. And yes, of course it applies when you're suing us, the county hospital in tort Hillsborough County.
Right, because 768.28 is a general law, just like the law in Stroop, just like the law in Sandringham. General laws, they apply to every county.
Let me ask you this, the answer of 768.28 is a general law in which limited waiver of sovereignty.
Yes.
What about, let me ask you this, in a mandamus action, while I don't governments assert sovereign immunity all day, every day in a mandamus action. You sue the Secretary of State, they said, because in mandamus to, put someone on the ballot or whatever, I have sovereign immunity. I'm sovereign, you can't sue me. I'm a division of the state government. You can't sue me in mandamus. Why? Why isn't sovereign immunity a good defense to that?
I think because they're not seeking money, Your Honor. They're seeking a declaration that somebody gets to be on the ballot, for example. That's not a monetary relief. They're sovereign immunity.
Talk to me about the Supreme Court provision, the Constitutional provision that you say establishes sovereign immunity and confines it to money judgment. I mean, I'm going to be speaking out of ignorance. Maybe I forgot that's what's in. Well, in other words, the mandamus actions to compel a ministerial duty, which happen, thousands of times a year all over the state against state and subdivisions of the state, to say, hey, there's a mandate, you have a ministerial duty imposed to you, and so presumably you can bring a mandamus action to compel a duty imposed by a special act, couldn't you? Could you? The ministerial duty, it's clear.
And
You have a right to the writ.
And before we get too much farther into this, you've got 5 minutes left, so we want to probably shift to some other issues at some
Okay.
point. But go ahead and answer.
Let me just say, in Hillsborough County, this court said, since Article 10, Section 13 of the Florida Constitution prohibits waiver of sovereign immunity by the passage of a general law, except by the passage of a general law of the legislature, prohibits waiver of sovereign immunity, except by the passage of general law, any waiver of sovereign immunity or attempts to create sovereign immunity by special act would be null and void.
We go round and round. I'm asking you why sovereign immunity is not a good defense, why it doesn't happen all day, every day, when thousands of mandamus actions are brought against all these governments all across the state to compel a ministerial duty. Why isn't sovereign immunity a good defense to that? If let's say that the duty derived from a special law, you can't get mandamus.
Your Honor, I haven't looked at the mandamus stuff in that context. I can tell you when they're seeking money like this, it is very clear, this court's written on it, or Supreme Court's written on it multiple times, it cannot be by special act. Cannot be, period.
Can't be that clear, because we've spent all the time arguing about it, you all briefed it to death.
Your Honor, I think there's been a lot of obfuscation here. I think it's confusing. This, again, that's this basis. We've cited a half a dozen cases that say you could only waive sovereign immunity.
Let's talk about waiver. Okay, let's talk about waiver. Okay, in this case, if there is sovereign immunity, it can be waived by a contract. So the way I look at this case very simply, you have the legislature imposing an obligation on the county. The county codifies that obligation basically in their code. The hospitals, in reliance on that obligation, treat indigent patients and submit a bill, and it's not paid. Why isn't that a contract?
Well, here are several problems with that, Your Honor. First off, and again, we come back to, you can't, the special act can't make the county do that. The county codification and the earlier opinion said, well, we're not just accepting this as ministerial. And that's part of what I think we're supposed to go back and have a trial on. How did this happen? The references you heard earlier to a couple of guys from the county said, oh yeah, this is what it says in the 70s or whatever. They weren't asked about sovereign immunity. They were asked, what's the term of the thing say?
Now, they paid for a long time under this rubric.
No, it did not.
You say they never paid?
There may have been some payments in the 60s. I don't think anybody ever established that because this case is about the codification from 2000, whatever. They really haven't pursued the earlier ones, as I understand it. We may ever change a position here, but the codification and the testimony was undisputed on this, was no thought at all. They took every law that was out there, special act, ordinance, and everything, and put them together so you could find them.
At least, yeah.
Less than one.
Okay, but well, I'm going right to this point, Judge, so.
Okay.
Appellants are gonna reply. Why is the codification so important? I mean, couldn't the contractual offer, unilateral offer have occurred prior to the codification and just out there and dangling, unilateral offer? It's existed for decades.
I think the state special act can't be an offer for the county. It's not. It's not on behalf of the county. If you're talking about a contract.
Before the codification from the 2003 year, what didn't the codification is of the ordinance that already, I'm confused.
No, the codification,
Just so you know.
well, if I could finish the question. Okay, the codification includes 2 ordinances by the county about how they're going to treat indigent pigs. 2 ordinances. That expresses the county's true intent. It also codifies everything else.
What are the 2 ordinances? Don't those 2 ordinances include the supposed promise to pay?
Under
shall pay?
No. They're discretionary, Your Honor. Those 2 ordinances are discretionary. They are different from the special act wording. That's a huge difference. That reflects the county's intent on what it wanted to do, and that's what the trial court found. It was not an intent to pay everything with no amount stated and so forth, with no contracted amount. So there is a huge difference in that. We've dealt with that in the brief, but I know I'm out of time, so I will. There's something else you want me to answer right now, otherwise I'll be back.
You did brief that. So.
Yes. Thank you.
Thank you. I appreciate that. We got 5 minutes, sir.
Thank you. First, I wanted to start with Arnold versus Shumper, because I know that's a case that the county relies very heavily on. And Arnold involved a special law determined to be unconstitutional, which raised sovereign immunity in the context of a tort action. And constitutionality and sovereign immunity go hand in hand. If the state goes outside its legal bounds and a law is determined to be unconstitutional, it might not be able to restrict the county's sovereign immunity in that situation. But here, we've got the situation where the county acted entirely, or the legislature acted entirely within its bounds. The Supreme Court's upheld the special law and imposed a mandatory obligation on the county. And so sovereign immunity is inapplicable in that. That case has nothing to do with what's happened here. And the county can't veto the state's action by invoking sovereign immunity. That would render a valid statute meaningless. What's clear from the county's argument is that its position is that if it chooses to assert its sovereign immunity to avoid a valid obligation, an obligation that the Supreme Court's upheld and that the legislature's imposed, it can do so because it's a special law. I mean, essentially, they're arguing that
Chapter 125, county governments wouldn't even exist, correct?
Correct,
That's
absolutely.
the only way they exist, by legislative authority. So any sovereign immunity they have flows directly from the legislature, correct?
Exactly, and right, and the only provision in the Constitution that deals with bringing suit against, Article 10, suits against the state. Provision may be made by general law for bringing suit against the state as to all liabilities now existing or thereafter originating. So, I mean, the county's argument, I mean, their only argument, and you can see their position is, they argued waiver. Their whole brief argued waiver. Their whole position in the trial related to waiver. They never addressed the issue of the applicability of sovereign immunity, and the judge didn't either in the trial court. They just focused on this issue of waiver. But as we've made, and the point we've made, and I think you've clearly understood, you don't get to waiver unless you determine that sovereign immunity.
If you do, the legislature imposed this obligation on the county. The county codified that obligation. The hospitals treated indigent patients in reliance on that. Changed their position, sent a bill, didn't get paid. How's that not a contract?
I think it is a contract. I think we briefed that extensively, and we think that the evidence supports that. I mean, the county raised these purported justifications for not paying. They were saying that we didn't observe certain processes. None of those processes are in the special act. We did exactly what the special act requires. We provided care to more than 40,000 indigent patients over, more than a decade, for really well beyond a decade, and expect to be paid for that care. And not, as I mentioned earlier, not only does that benefit the county, it benefits the indigent residents of the county. The county wants to basically say it can disregard a policy set by the legislature if it chooses to do so. In the Freed case, as I mentioned, just this year, the Supreme Court reasserted the legislature's primacy over inferior local governments such as the county. And we believe this is absolutely a mandatory obligation. We're disappointed that it's taken us this long to get to this point, and we certainly hope the court affirms or reverses the trial court's decision and instructs it to approve the declaration that we've sought and mandate that the counties receive payment. So we do hope that the court issues an order with instructions to the lower court so that we're not back here again arguing over whether the county is trying to evade its obligation.
But could you, for the slow tip in class, we address the issue about the convocation? I mean, I think, I'm not misunderstanding what Charlie was talking about, but the idea that the ordinance prior to and after the convocation are different.
I think that's a distinction without a difference. I mean, they first codified the ordinance in '63.
Right.
They then did it again at a later period, and then finally in 2000 they did it the third time. I see no distinction. I mean, the county began, as the court noted, and there was no dispute. The county did make payments under the local law at earlier dates. The county contended that after '72 the payments were made under another law, but that's meaningless. It doesn't matter. The county even made the argument that special law expired, and laws don't expire. Those arguments were rejected by the Supreme Court, or those are established principles, and the Supreme Court rejected the argument that there was a payment obligation under 125 or 12709 as okay, thank you.
Very interesting case. You all did a great job with it. Your briefs and your arguments are very helpful to us. We're grateful for that. We're going to hear round two now, and maybe we'll pick up some different things or hear some things again that we hear differently. Okay? So our next case is Venice HMA versus Sarasota County. Reserve 5 minutes, sir?
Yes, thank you, Your Honor. We'll reserve 5 minutes.
Before I make the mistake I made before, do we have an understanding when Mr. Wallace is going to get a chance to talk?
We have an understanding that I am going to talk briefly, and I'm either going to be first or last, but it's up to Mr. Elliott, and I'll accept either one.
That's fine.
You can go first.
That's fine, okay. Yes, sir, we're ready.
Jeffrey Smith on behalf of Venice Regional. I had prepared kind of brief remarks because I thought we were going to consolidate, but I've never been known to.
We're not going to punish you if you don't take all of your time.
I hope I get it all done. I did want to take a couple minutes. I'm not going to repeat everything that Mr. Acina has already presented to the court, but I did want to just emphasize a couple. There were some questions from the bench about the argument on law of the case and the meaning of the Florida Supreme Court's upholding of the Special Act in the face of the Home Rule challenge. And I would just simply say, if you go back and look at the argument presented to the Supreme Court, the essence of that argument was that the county,
What case can you point to about the law of the case that would support that opinion established as law of the case that sovereign immunity didn't apply? You have to raise the argument has to have been necessary to the prior decision, the argument has to have been addressed, has been adjudicated.
yes, Your Honor. So the case law that we would point to, we cited in the reply.
It's like law of the case by implication.
That it's by necessary implication is what the case is
So
holding.
it was necessary, so that's.
And that's what I'm arguing exactly.
Because explain why sovereign immunity is necessary.
Because the essence of,
A completely different defense was raised.
and I respectfully disagree that there,
Defense was necessary to adjudicate the completely different offense that was on appeal.
and with all due respect, Judge Atkinson, I don't see them as being completely different defenses. They are, when you look at the essence of what was argued, in both instances, the county asserted this special act can't impose this obligation on the county because we, the county, as the sovereign, our home rule power, we the county, have exclusive authority over our budget, over our taxation, over obligations that'll be imposed upon the county. And the arguments, if you were to lay them.
They're so different that it actually dovetails into the point that Judge Morse was making, which is you're talking in home rule, in the home rule scenario, it's a tension between the state and the local government. And then in a sovereign immunity, you're very arguing you should embrace the distinction because there's a distinction that helps you in the sovereign immunity arena, because sovereign immunity is between a private actor and the local sovereign.
I agree, I embrace it wholeheartedly, Your Honor, but the distinction of the arguments, the underlying essence of these arguments, what we're being asked to believe is that the learned judges of the Florida Supreme Court had in front of them a case been pending for 6 years. It's before them. The issue is, does the county's authority over its purse strings, over its budget, protect it from monetary damages? It's in essence an argument you can't sue the sovereign. And at its core, we're being asked that our learned judges of the Florida Supreme Court said, no, we're going to enter this order and say, home rule, all these arguments about our power over the purse, we're rejecting all those arguments about that power, yet if they had only uttered the word sovereign immunity, then it'd be a whole different ball game, and we would say, oh, well, yeah, now that you're putting it in that framework, we're going to uphold that. I think by necessary implication, it's addressed. I have nothing further on that issue. But, I wanted to address primarily today 2 arguments that I don't think have been raised. And one of them has to do with the inapplicability of sovereign immunity where you have a situation like this, where there is a general law that allows for adoption of ordinances to do things like create hospitals and provide for the welfare of the public with those hospitals. And the county acts.
A specific obligation to pay hospitals is not derived from the general law.
I'm sorry, can you?
You'd agree that the specific obligation in which your client brought suit was does not derive from a general law. It derives.
No, the line of deriving the authority is in 125.01.
You do a bunch of stuff as a city.
Well, and one of the bunch of stuff, Your Honor, is you can enter into contracts. That's one thing. And you can also adopt ordinances for hospitals and to provide for the welfare of the public, which leads me to this point. We've heard from the county that there's 2 ways and only 2 ways that sovereign immunity doesn't apply. One is if it's unequivocally waived in a general law, and the other is an express written contract. Well, where did that come from? Where did this notion that an express written contract is a way that sovereign immunity doesn't apply? It's not in the Constitution doesn't say that. Article 3, Section 22 doesn't say that express or written contracts are an exception to sovereign immunity. And what the court did in the Pan Am case was they looked at the power, the general power granted to state agencies to enter into contracts. Just the general grant of authority in a general law that says you state agencies have the right to enter into contracts.
So you say in Pan Am, the rationale was that a general law conferring on counties the right to contract waived sovereign immunity to the extent that they do contract. And here you're saying the general law in 125 allowing counties to establish hospitals and provide welfare benefits. Waive sovereign immunity from any contract.
It's not so much.
Waive sovereign immunity for any contract.
It's not.
Even if that contract is pursuant to special law.
If I could articulate it this way, the Florida Supreme Court didn't use the word waiver in the Pan Am.
How does that get you anywhere? Because you're still at the same square one, because a contract, regardless of whether the contract, if you can approve the contract, you win, because Pan Am already established that the general exception regarding contracts was derived from the general law giving counties the right to state, county subdivisions right to contracts.
I'm going to put aside the contract argument because I agree with you. I agree with you, yes. The fact that the county is empowered to enter into contracts, and if there's a unilateral contract, and I won't go down and repeat all those arguments, but if there's a unilateral contract, then yes, this is on all fours with Pan Am. It's you're empowered to enter into contracts. You did enter into a contract. It's an express contract. It's written in the ordinance, and yes, that's one of the bases that would waive sovereign immunity. But the other basis, Your Honor, is that just as in Pan Am, where you have that general authority to enter into or adopt ordinances that provide for hospitals and the general welfare, you don't have to as a county. It doesn't say you shall do that. But when you do that, then just like in Pan Am, it would be illogical, illusory to say you can create a system for reimbursement, but then when the people that are entitled to reimbursement sue you to recover, you say, oh no.
By that rationale, you're saying that 125 because the legislature conferred on counties the right to have welfare programs. If independent of any specific mandate, Sarasota County started a welfare program, a food stamp program, that they would not be sovereignly immune from suit based on that.
Correct, Your Honor. You would not. If the county adopts a program pursuant to general law, or if they enter into a contract pursuant to general law, this is what Pan Am holds. It would be illogical and illusory to say the county can do that.
Rational Pan Am.
I think it is, Your Honor. We may agree to disagree on that. I think that is exactly what the logic of Pan Am.
One of the functions of the city can be subsumed within Chapter 125, and that's driving a dump truck down the road or driving a garbage truck down the road, and then the garbage truck runs over a plaintiff's Shih Tzu. They still need 768-28 to sue the county, because just the general 125 law allowing counties to perform functions like driving garbage trucks doesn't waive sovereign immunity. So likewise, Chapter 125's general provision allowing counties to have welfare programs doesn't waive sovereign immunity.
Your Honor, I guess hard to follow that analogy because you're throwing in you're throwing in a tort claim issue. But I would say this: if there's
my point is that Chapter 125 gives, just by virtue of giving the county the right to provide for general welfare, which might include garbage services, was enough to waive sovereign immunity with regard to a service provided pursuant to that general authority under 125. 765. And why would you need 76828 to sue the county when the garbage truck runs over your Shih Tzu?
Because the ordinance wasn't addressing tort liability. Now, if the situation was, the county says, I'm going to adopt an ordinance that says, folks that go out there and pick up garbage, you'll get reimbursed by the county because we want a nice, clean city, and we're gonna have an ordinance that says all the people that own trucks, that if you pick up garbage and you take it to the dump, we're gonna reimburse you for the cost of doing that. I think that, yes, when they do that.
Now you're saying the special, you don't even need the special act to establish sovereign immunity.
Right.
Now you're saying you don't even need the special act that imposed by state mandate on Sarasota County, the requirement of the hospitals.
Good segue. I want to go to my second topic, because that is exactly the point. When you say this was imposed on the county, I disagree. And the unrefuted evidence of record is that the county adopted the special act verbatim in 1963 in the ordinance. It's in our brief. The citation copy of the ordinance is part of the record. They did it again in 1971, and they did it again in 2000. They adopted it as part of the Code of Ordinances of Sarasota County. And what they want to argue is that, and what they argued below, and the trial judge accepted, is, oh no, we didn't really intend for that to mean anything. It was just a handy way of referencing special acts. It was just sort of, we put them all in one place so the public could find them. And they put on testimony to say that was the point. This court hit the nail on the head, and here's what this court said last time we were here. In its filings before us, the county suggests that its ordinance adopting the special act was merely a ministerial act that had no real legal significance. We reject that dismissive view of what this local legislative act was, an almost verbatim adoption of the special act by Sarasota County. And they did it not once, they did it 3 times, and they didn't just say, oh, well, here's reference to special acts, and you go to the special acts. They renumbered the provisions to be part of the Code of Ordinances of Sarasota County. That, Your Honor, is adopting the ordinance as an act of the county and then trying to renege on it. And this is where the history is important, and we've cited to the history of payments that were made. And one of the responses has been, oh, that wasn't made, those payments weren't made under the special act as adopted by the county in its Code of Ordinances. They were made under Ordinance 7279 passed in 1972. Well, problem with that argument is that payments were made in 1963, 64, etc. It's in the record. The payments predate Ordinance 7279. They couldn't have been made under 7279. And the second point is the record shows, it uses the word, these are certified. That is language, that certified list language comes right out of the special act. So those are the 2 main points. I don't know where I am on time because there were a couple of other.
You're right on, 15 minutes.
Okay, well then I'll wrap up right there.
All right.
Thank you very much.
So much for a few comments. Mr. Wallace, at long last.
Yes, thank you. I think we've agreed I'm going to go first on this round. I'll try to be brief. The first topic, I have 3 topics I think I addressed in our brief. The first one has to do with the judgment for the hospital district that appears in paragraph 38 of the final judgment, and an extension from that, how the parties addressed that in their briefs. There was a judgment for the hospital district for the simple reason that the case went to trial on count 1 of Venice's complaint, count one of Doctors in Inglewood's complaint, and there are no claims against the hospital district in count one. So if you read paragraph 38 of the final judgment, it's a judgment for the district because we were there with no claims against us. If you look at the wherefore clause.
So it is an
no-
oddity that you're in this case and that you've aligned yourself with the county, even though you're a payee and not a payor.
Right, and then there were a couple
Maybe
of.
it's none of my business, but it does make you sort of want to ask some questions.
Sure, and I'm happy to answer it. The first and foremost, around, we're talking back, a decade, 15 years back, the district determined that the special act, for the same reasons the county didn't think it was enforceable, was not enforceable. So that's one point. The practical reason is we got sued by the parties, Venice, Doctors, Inglewood, and we got sued not just, there was a count two in the complaints until a year or so before trial, and count two was directed against the district. Had to do with something that we're not even here about today, which was about the transfer of patients.
Your interests are aligned with the hospital.
Yes.
But apparently that is not the case.
It is not. We just don't think the special act is enforceable in this way. And we've maintained that position for now 15 years or whatever, 10, 15 years, and we still contend that's the case.
What if the district's rationale for why it's not enforceable?
Well, at this point, we agree with the sovereign immunity issue, and I'm going to address that very briefly from a different perspective on our second issue. But the district's position is simply that it appears there in a special act, and it's not enforceable because they can't waive sovereign immunity by special act. And I don't want to restart the whole thing, but what our position is that if you take a mandate language in a special act and say, well, you have to enforce that because it's mandate language, it's effectively waiving sovereign immunity by a special act. We don't agree with that. So we stand with the county on that. As to the judgment against the district, we shouldn't have been there at trial. We tried to get out on summary judgment before trial. We tried to get out in the middle of trial. We finally got out at the end of trial because there were no claims against the district. But that's as to the judgment against the district, and I direct your attention to paragraph 38 of the final judgment, and also to the wherefore clauses of their complaints. And I actually skipped over that the parties didn't argue about the district in their briefs. The only argument about the district in their briefs is at page 66, footnote 6 of the Doctors in Inglewood brief that appears actually below the page where their conclusion lies. And Venice adopted their argument, but that's not an argument that can be maintained as a preservation for appellate review, and we addressed that in our brief. So that's the first point. Second point is kind of a practical point, which is, and this goes to the issue that if we're talking about sovereign immunity by a waiver by express written contract, the district has been in this same arena for the same period of time with all of these players. The district has never contended, and the trial evidence supports this, has never contended that the district was in a contract with the county. And we believe because the same events would have formed a contract with us as might have formed a contract with them, we think that's relevant to whether or not they had a contract. So that just shines a light on that. And on that point, just from a practical matter, we've got 3 large private hospitals, 1 large public hospital, 1 large unit of county government. Nobody thought there was a contract, ever, until they were forced to look for one.
Yeah, and I read those arguments in your brief, and I appreciate what you said, but I really don't know how that actually matters.
Well, I think it matters.
Nobody thought there was sovereign immunity either until after 6 years of litigation. So
Well, I think it matters that the private hospitals for years said there wasn't a contract, and then when forced to look for one, then they say there is a contract. So I think that it shines a light on that issue. But from our perspective, we never treated it as a contract. and none of the other parties did either. One last issue, which has to do with the EMTALA issue, and I'm going to address this on two different levels. First of all, EMTALA, of course, is the federal law, and there's a state counterpart that requires that if somebody walks into the emergency room, they get treated to a point of stabilization without having to show that they can pay, without having to pay, without showing insurance, of anything of that nature. That, of course, didn't exist when this law was written in 1959.
But it did in 2000.
It did.
When it was codified.
It did. And I actually think that the fact that the language did not change when it was recodified in 2003, if that's the recodification you're referring to, recodification of our special act. The definition, there's really only one definition in the indigent care provision. A medically indigent person is one who requires care and who is unable to provide himself or herself with such necessary hospital services. Our point is really, well, again, I'm going to make this on 2 points. First it goes to the formation of a contract, and that is that there can't be consideration because the hospitals are all required to provide the care that they provided, that they claim reimbursement for under this special act. They're already required, so there can't be consideration for something that they're
Is there a
required.
Venn diagram here between the care that's required under the acronym that starts with an E?
I missed the first part of your
Is
question.
there a Venn diagram issue here where the care, the stabilization care, and then the care that they might be billing for, that may exceed that?
Yes, and I'll address that. I'm not saying that there can't, I know that one of the responses to the second part of my argument had to do with, we're saying that there can't be a medically indigent person. We're not saying that. What we're saying is that the folks for whom they're claiming reimbursement in this case are not medically indigent persons because they're all through the emergency room. And so everybody who can get
This
treated,
goes to the consideration issue. You're not saying that they don't constitute indigent people under the special act or the CAP ordinance. Or you're saying you're.
I'm saying both. I'm saying both. The first thing is,
On the issue of whether they meet the definition under the act and the ordinance, how is getting walking to a emergency room and having a federal mandate obliged to provide services, providing himself with services? That sick person is not providing himself with services. He or she is not paying for it.
and our point on that, Your Honor, is that that patient has been able to access care and be treated.
That's not providing himself with service.
Well,
Yet, he's able to receive services.
well, they have accessed the care and in most cases probably gone home. They don't have to provide insurance. They've gotten the access to the care. My point is, when this was originally written in 1959, it was about ensuring access to care. And in 1994, after EMTALA was passed, that same person can walk in, get that care.
Well, it's beyond the scope of what we're doing here today, but if the legislature obviously had a problem with this, they would have fixed it, maybe.
A problem with this language in the special act?
Yeah, I mean, this has been battled a long time. I can't imagine that there's not some legislative awareness of this. And I would imagine if they had a different thought about what this should address, they would have done something. But again, it's beyond the scope of what we're doing here today.
I'm not aware of any effort to change the special act, even during the life of this thing on this particular point. But it is beyond what we're here about.
Yeah.
But
So you're also saying that it defeats consideration because.
it defeats the consideration because.
They're not providing anything that they would not otherwise already provide.
Exactly,
I'm sure they'll have an argument
exactly.
against that.
But yes, we do make the more basic point, Your Honor, which is that we don't think these are medically indigent persons. Because the special act doesn't say indigent and it doesn't say uninsured, but those are the only measures that the private hospitals use to determine whether these folks are medically indigent persons. And unless, I don't want to take up more time than I should, but I'm happy to answer any more questions. Hearing none?
You could preemptively.
Okay. Mr. Elliott, you have 9.5 minutes.
Thank you. Your Honor, I'm going to start a point that hasn't been discussed yet, although it's in our brief. And that is if you look at footnote 26 of the trial judge's order, and that's at page 22665 of the record, she makes a finding that even if there wasn't, even if they could establish a contract, that they didn't comply with the terms of the special act, with the things they had to do to get paid. She makes a factual finding of the deficiencies. So even if you were to say, well, we think it's a mandate, we don't think so, that doesn't matter. This still needs to be affirmed as it is now. They can come back down the road and try to do it. Pardon?
What about the declaration? Are they entitled to a declaration of entitlement to payment? Even if they didn't, even if we agree that that's substantial evidence supports that they didn't do what they needed to entitle themselves to.
If you were going to rule for them, that would just be a declaration going forward for future care. That would be what, but now let me turn to why you shouldn't rule for them. Because every special act is passed by the legislature. So to say, well, the legislature told them to do this and the legislature can dictate what they want, no. Our answer briefs at page 20 in both briefs, we detail a half a dozen cases, and there are more that say that only general laws can waive sovereign immunity. Only general laws, not a special act. Telling them, the legislature saying a special act, you got to go do this one particular county. That the county does not, if it's paying money, the county does not have to do it. That's what sovereign immunity is, and it's in the Constitution, and it trumps coming over what the state may say, what the legislature may say in a particular thing. And the Supreme Court, there's a half a dozen Supreme Court cases we cite. Again, look at page 20 of each brief. The Pan Am case broadens that in 1984 and says, well, if you enter into a contract, okay, that's a court-made rule from the Florida Supreme Court, so we're going to follow that. If you enter into a contract, that's different. The Pan Am case is a good example. It is a written contract for vending machines in prisons. You had an actual contract. That's what a contract looks like. They didn't have that here. As to the question about not waiving or not raising it for 6 years, no, sovereign immunity was there from day one. It was pled as an affirmative defense. There was an effort made to go first on the immunities argument, which initially prevailed. And personally, still think you were right on that. But that is sovereign immunity, and as far as these past payments go, sovereign immunity can be can be raised at any time. So the fact that you paid a payment in the 60s or paid a payment some other time, you can raise it anytime you want. Again, we've got the case law in the brief on that. That's undisputed. You can raise sovereign immunity anytime. Are there any questions? We would ask you to affirm. The trial judge is right. She did what this court said. This argument about a mandate, quite frankly, is just a reason to try to, it was basically an admission they can't prove a contract. There was not an offer for the reasons the judge found. There was not acceptance. They never said, okay, well, they sent full priced bills. That's one of the problems the trial court had on that level. They didn't discount it. They're supposed to do it the way they.
It's about acceptance. So unilateral contract requires acceptance, and there's the
mirror image. Yes.
I mean, what is the performance? Is the performance of treating patients, or is it? I mean, how granular must their non-compliance with the offer be to defeat acceptance? There's a distinction, of course, to be drawn between, a defense to a breach of contract action because of failure performance. But here we're talking about contract formation. So, they said, we treated the patients and we're submitting invoices, or pardon my ignorance of what the term
and the treating the patients isn't consideration because they had to do it anyway.
Well, I'm not talking about consideration, talking about acceptance.
Acceptance.
Performance is acceptance by performance.
Well, if they're going to perform, if there were an agreement and they were going to perform under it, they need to follow strictly the terms to get paid. And the special act lays those out, and the judge
But
found.
could the contract have been, so that's the interesting scenario here. The distinction between defense to payment and defense to, and the establishment of the defense sovereign immunity. So in other words, the performance is the degree of, in other words, so is a substantial performance something that could establish acceptance under the rubric of the unilateral contract?
No, Your Honor, as you said earlier, mirror image, the Sanchez case, and it went to the Supreme Court, but the Supreme Court reiterated mirror image. You need a mirror image, you need
But
an
the
exact.
Sanchez case was an opposite. I mean, how does kind of turned out a little differently, really, not necessarily favorable to you. In other words, you know, they said, hey, it wasn't.
They reiterated the mirror image rule, which is what you referred to earlier.
Incidentally.
Which, well, but that's crucial in this case, because there is no mirror image acceptance of the offer. They come in, they only have a price. You know, it was, this opinion said before, it was over $500 million, you know.
So we're talking about the existence of the contract, right? Not, you know, so because it's possible that the substantial compliance with the performance obligation for the purpose of establishing a contract by performance as acceptance could be less stringent than required to perhaps defeat summary judgment based on breach of contract.
Okay. They never pled breach of contract, so we didn't get to plead our defenses to breach of contract, okay? Because the judge said it's not pled, so you're not going to do your defenses. We asked to amend
No,
the
I
defenses.
agree there.
But, you know, they're not talking about a written contract where you can say, look, this is substantial performance. They need to perform strictly under Section 8 and 9 of the Special Act, if that's what they're going to travel under. And they didn't. They didn't do the certifications. They put gross amounts in. They did a whole bunch of things wrong. And the trial judge spells that out and says, look, even if you were right, you're not getting anything up to now. Now, if you get a declaration, we obviously don't think that should happen. But if you were to declare that, okay, well, they can proceed under that, they got to be going forward because they can't fix what they did before.
You're saying by virtue of the finding that they didn't perform up until now, that shouldn't really go to damages, but that should go to actually the issue of whether sovereign immunity was waived at all, because by failing to perform, they failed to accept, and by failing to accept, the contract failed to come into existence.
Both. I'm saying both, Your Honor. I'm saying, A, it goes to whether there was a contract formed, but B, even if you were to find, okay, this is enough to cobble together for a contract, the court made a factual finding they did not comply with the terms of the contract and they're not entitled to payment. And we detail that in the briefs. And so it would be a forward-looking only. They would not get any money prior to now. So with that, we'd ask you to affirm. Thank you.
Thank you. You have 5 minutes.
Thank you, Your Honor. Briefly would address a point raised by Mr. Wallace on the district's historic view of the special act. I just want to refer that the district had a different view in the past. If you look at the record, they received payments under the special act before 1972, so it's not that, 72, 79. I'll just cite you to the record 14767. It's detailed on in our brief on page 9. Also, point out that the district itself submitted an invoice to the county in March of 2009 for payment under the special act of $8,141,763. That's in the record at 5406.
Can you refer to that regarding performance?
The district, I'm referring to the fact that the district submitted this and their view, I'm responding to Mr. Wallace's, the district's view is there's not a contract, there's sovereign immunity. We agree. That's whistling a different tune than in past actions. In 1999.
That's not irreconcilable. They could have said, hey, can we have some money?
I mean, from what I can tell,
I guess we can't sue you because you have sovereign immunity. That's not.
Everybody's changed their position over time.
I agree. I'm just pointing out, Your Honor, that there has been invoices submitted.
Again, that doesn't admit that they could bring a suit and overcome sovereign immunity. They were just had their hand out asking for money.
on page 12, we discuss, and I guess the last thing that is somewhat important to understand about all this, why did they change their position? And this is also in the record. There was, after they submitted a bill for $31 million in 1999, the county and the district agreed that the district should go ahead and use its own ad valorem tax authority rather than hand out to the county with its ad valorem taxes. Said, you use your ad valorem tax money to fund indigent care. And from then on, that's kind of the direction that the district went. That's fine. That's happened. That's a settlement agreement that was reached. My point is that as private hospitals, we don't get to say, well,
You can't tax people.
right, we don't get to tax people and say, well, let's just shift it from the county over to our.
Can you address the issue of the deficiencies of performance?
Yeah, very, very quickly, I will, Your Honor. I don't know how much time I
To
have.
the extent it impacts whether contract formation.
Yeah, the issue of the deficient performance, the issue that was raised primarily with Venice was you didn't submit itemized bills. And if you look at page 15 in our brief, this is in the record also, when the bills were first submitted, they included detailed itemized.
You're saying they frustrated performance. What I want to know is, do you have cases that suggest that some substantial performance in the milieu of a unilateral contract can constitute acceptance by performance?
As opposed to mirror image or regurgitation. The cases that are cited in the other private hospitals brief on there didn't need to be exact regurgitation. I don't have them at my fingertips.
I
But
mean, I look at this as acceptance, as the hospitals agreed to take the patients.
correct. I
Payment
agree.
is the fruit of the contract, not part of the contracting process.
I agree, Your Honor. That's exactly what was. Brief comment, if I have any time, on EMTALA and the State Access Act. Complete red herring issue. Those acts, I deal with them routinely. EMTALA simply says hospitals cannot refuse to provide somebody care. Doesn't speak to the person's responsibility to pay for that care. If an indigent person walks into the hospital, it isn't, hey, free care today. It's, we'll treat you, we'll address your emergency, we're not going to let you die. But
what about the more general issue about whether consideration can be established by performance of duty on independently others?
right,
You
and
have 10 seconds to answer.
okay. The duty is to provide care. The duty is not to refrain from reimbursement against indigent people who have no means, and that's the rub, Your Honor. Thank you.
You all are great lawyers, and I appreciate having really good lawyers on these cases because we need all the help we can get, and you were very helpful to what we have to do now. So we're adjourned, to sort this out, figure out what to do.
Thank you.
All rise. Thank you. Travel safely. Thank you.